that, like all the best histories, cut through familiar narratives, and in his case, force us to reconsider what the early national state actually was, what it did, and how it was experienced by the people who lived under it. His work is also notable for its methodological breadth, combining political history, fiscal history, state-building theory, and international perspectives, and using them to illuminate what the American Revolution and its aftermath looked like when viewed partly as a constitutional drama, but also as a profound transformation in the structure of governments. He's perhaps best known for his landmark book, A Revolution in Favour of Government, which demonstrated that the framers' project was not primarily about protecting individual rights or limiting state authority, or at least not in the way we tend to usually think about that. Instead, the Constitution, in crucial ways, was really always intended to be a nation-building document designed to create a stronger, more capable federal state, right? A place that could raise revenue, manage public credit, participate effectively through those things in the geopolitics of the late 18th century. And it's actually quite difficult, I think, to overestimate how influential that reinterpretation has been, particularly as it's been extended since then throughout his subsequent books, Hercules in the Cradle in 2014, and Perfecting the Union in 2020. The first on the rise of American public finance in the early republic, the next on the relationship between national and state governments under the Constitution. So basically, what we have here is one of the most Kinder-adjacent moves imaginable. So in Max, we have a Swedish guy whose work bridges American and British historiographical traditions to bring the kind of comparative perspective that helps us see early America within the broader history of state formation and conflict. So we're in for a treat for this afternoon with this talk on St. George Tucker and the invention of the Constitution. So let's welcome Max.
Thank you very much for an extremely generous introduction. I'm not sure if even half of that is true, but it's going to be here anyway. So I'm going to start by saying that it's wonderful to see how popular St. George is. I have no idea. It looks like we could start a bankrupt and maybe produce a t-shirt. I do like that image. I want to say also take the opportunity to thank the Kinder Institute for hosting me and everyone here, faculty and staff, including student ambassadors, for making me feel so extremely welcome. It's really been a wonderful few months. To the rest of the year, I've also very much enjoyed exploring this part of the country where I've not spent time before. So the beautiful state of Missouri, and also equally beautiful states to the west, which I will not. So no, thank you everyone for making my stay here such a wonderful time. So Billy asked me many months ago what I would talk about this, and it seemed fitting that I pick it something that had to do with Kinder Institute's focus on constitutional democracy. So when I was casting about for topics, I decided in the end to do something on the written constitution, which is America's great contribution to political modernity. And just to brush up your knowledge on constitutionalism, a written constitution is an agreement between rulers and the ruled, restricting government and securing individual rights. It's a central element of something called liberal democracy, which is the political system that dominated in the West in the 20th century, and which also, for a brief period of time up before the Berlin Wall, looked like the only game we had. So the origin of the written constitution is conventionally dated to the American Revolution. 11 colonies wrote constitutions as part of their bid for independence from Great Britain. With the French Revolution, written constitutions spread from the United States first to Europe, then South America, and then further beyond. And we saw the age of of revolutions, that's 50 years spanning the year 1800, centered on the year, was really very much an age of constitution writing. At least 60 new constitutions were written in Europe alone in this period. And because of this seemingly instant success of this American invention, superstar historian Gordon Wood has called the state constitutions that appeared in 1776 and 1777 the most important of the extraordinary contributions the Americans of the Revolutionary era made to the world. So my talk this afternoon grows out of my interest in the man you see here, the Virginia judge and law professor St. George Tucker, and this is a project that's been sitting on the back burner for many years now. I was first drawn to Tucker because I can use him and other jurists writing in this period to study American state formation. And as Billy said, this is a topic that I've written on before, quite a lot in fact, but so far my work has been shaped by modern concepts of the state and modern theories of state formation developed by historians and social scientists. And this time I want to write more of a kind of an inside story of how the founding generation themselves described the formation of the American Federal Republic, so using their own words. And when I start to pay attention to their terminology and to their theories, I start to see things in new ways. So, just to give you one example, before I started this project, I really didn't know that 18th century political writers used the term state to refer not to government, but to the people or to the nation. That means that our modern distinction between state and society would have made no sense to them at all. The words meant just simply meant the same thing. Now, if this is true of what the founders thought about the word state meant, we can start to wonder about how we should correctly interpret the name that they gave to their new nation, the United States. There is, of course, a close connection between state formation and constitutions, because constitutions are used to create governments. And Tucker is interesting because he sheds light on a shift in the meaning of the word constitution that allegedly happened during the American founding. So before the revolution, the word was rarely used to written plans of government. Colonial charters, for example, were never called constitutions. During most of the 18th century, the word instead referred to what we today would probably call a political system or political culture, essentially a country's political institutions, its practices and principles as they had developed over time. With the American Revolution, constitution instead came to refer to a single document text that expressed the fundamental law of a country. And this, of course, is what constitution means today to everyone except the Brits. Searching for explicit definitions of constitution from before 1776 shows that they are quite rare, and if you start reading the literature, you'll see that historians go to the same source when they want to find a good definition of this pre-76 definition or understanding of the Constitution. So they often turn to a book by an English politician called Lord Bolingbroke, who wrote a book called A Dissertation on Parties, published in 1733. In that book he says, by constitution we mean, whenever we speak with propriety and exactness, that assemblage of laws, institutions and customs that compose the general system according to which the community hath agreed to be governed. So according to this definition, a constitution is a system and that is constantly evolving. This means that the actual content of the constitution is going to vary over time. Although Bolingbroke mentions that there is popular agreement to the system of government, the community hath agreed to be governed, such agreement is tacit. It's not registered by an explicit act of adoption. We can compare this definition to one made by James Wilson some 60 years later. And this is the James Wilson who signed both the Declaration of Independence and the Constitution. He was a US Supreme Court judge, and he was also, for a brief period of time, just like Tucker, a law professor. And in that latter capacity, he wrote that by the term Constitution, I mean that supreme law made or ratified by those in whom the sovereign power of the state resides, which prescribes the manner according to which the state wills that the government should be instituted and administered. From this Constitution, the government derives its power. By this Constitution, the power of government must be directed and controlled. Of this Constitution, no alteration can be made by the government, because such an alteration would destroy the foundation of the government's authority. So in contrast to Bolingbroke, Wilson's Constitution is created by an act of the people, or in his terminology, an act of the state. Because it's the instrument that creates government, the Constitution is both antecedent and superior to government. We can see here that Wilson makes no mention of the Constitution being written, and that's most likely because he simply took that for granted. Now, when historians like Wood say that the modern idea of a constitution as a written document was one of the most important innovations of the American founding, they're not in fact interested in words being put to paper, but in the shift in the meaning of the word constitution represented by these quotes from Bolingbroke and Wilson. The term written constitution is therefore something of a misnomer, and historians should really be speaking about a documentary or a single document constitution, because the real claim is that the American Revolution represents a giant leap forward in making in turning the abstract concept of the people as constituent power into practical reality. So in other words, their constitution is the one that Wilson spoke about, the antecedent superior constitution adopted by a sovereign people to set up their government. During the American founding, the constituent power of the people acquired a concrete form by the invention of the Constitutional Convention and popular ratification. This, according to the historical narrative, was a gradual process that was only completed with the Massachusetts Constitution of 1780 and the US Constitution of 1787. So strictly speaking, the written word is not needed for the people to act as the constituent power of government. Strictly speaking, both constitutional conventions and popular ratification could work without writing. But in a literal legal culture, in contrast to an oral one, writing becomes part of government constituting by default, because agreements and forms of government are documented and promulgated in writing. Still, there is something more to the written constitution than mere convenience. In the age of revolutions, ideologues on both sides of the Atlantic began to argue that writing was important in its own right, because the written single document constitution made the constitution transparent to the people, a necessity if democratic government were to take root and to thrive. A famous exchange between Edmund Burke and Thomas Paine over the British Constitution is often singled out as the moment when this understanding of the written constitution was first clearly articulated. And I'll come back to this exchange later in my presentation. So far, what I have summarized is what used to be the received wisdom about the written constitution and the American founding. But in the last few decades, the claim that the American founding invented the written single document constitution has been vigorously challenged by impressive new scholarship by legal historians and by occasional historians writing legal history, who battle against so-called constitutional originalism. So this scholarship argues that, contrary to conventional claims, the revolution did not in fact cause a sharp break in American constitutionalism. that the new state constitutions written during the revolution did not replace the older understanding of constitution as a system or assemblage, and that no one at the time paid any attention to the new state constitution's writtenness. To quote one iconoclast, if the writing of constitutions beginning in 1776 marked a decisive break with the past, we should expect to find relentless testimony to this fact, yet we find no such testimony, and the silence is deafening. At present, I don't have any wish to contest this new scholarship, this new literature, which looks sound, given the premises. I rather approach it as an invitation to discuss how American constitutionalism evolved during the American founding, and this is where Tucker enters the conversation. He was writing some 2 decades after the adoption of the revolutionary state constitutions, some 5 to 10 years after the adoption of the federal constitution, and he strongly believed that the written constitutions appearing during the American Revolution were something that was both new and also very important. And this takes me to the title of my talk. I'm not arguing that Tucker single-handedly invented the written constitution. In fact, he attended neither the Fifth Convention that wrote the Virginia Constitution in 1776 or the Philadelphia Convention that wrote the U.S. Constitution in 1787. My claim is much more modest. I use the word invention to convey 2 things. First, that Tucker consistently reported on constitutions, and not least written constitutions, as an invention of the American Revolution and as something fundamental to American post-independence political organization. To Tucker, the written constitution represented an important improvement central to a system of government that he called representative democracy. Implied in his argument, but never spelled out, is the belief that this innovation would be emulated elsewhere. The second reason why I use the word invention is that I want to propose that Tucker helped determine the meaning of the Trump Constitution through his reflections on the political function and form of constitutions. So based on very preliminary readings of contemporary theorists, my sense is that Tucker was a relatively sophisticated thinker. As yet, I don't really know anything about his influence on later American constitutional thought, and going forward, I will have to investigate the theorists who followed him. Now, Tucker is not a major god in the founding pantheon, but he's far from unknown among experts. But I'm guessing that not everyone in this room will have heard of him or of his principal work, Tucker's Blackstone, published in 1893. So we definitely need a brief introduction to the man and his writing. Tucker was born on Bermuda in 1752. He went to the College of William and Mary in Williamsburg, Virginia, where he studied law with George Wythe, a legendary teacher who also taught people like Thomas Jefferson. Tucker remained in Virginia for the rest of his life and replaced Wythe as professor of law and police at William and Mary in 1790. Although he trained as a lawyer, he married into the Virginia elite and thereby came to be a slave plantation manager on behalf of his stepchildren. He was very much involved in the system of slavery, owned slaves, and also wrote a plan for the gradual emancipation of slaves in enslaved people in Virginia, which was published in 1796. With his first wife, Frances Bland Randolph, Tucker had 2 sons who lived to adulthood, Henry and Beverly, who are in the middle of the slide. Both men became lawyers and both eventually became law professors at respectively the University of Virginia and William and Mary. To Beverly, there's a local connection because he lived in eastern Missouri between 1817 and 1834 when he went back to Virginia. Tucker's youngest stepson in his first marriage, in the lower left-hand corner, is John Randolph of Roanoke, and he had it was a moderately successful career as a national politician, and you know, political historians of the earlier republic will have heard about it. So, Tucker was appointed professor in 1790, and he was at that point serving as judge on the Virginia General Court. That meant he had no time to prepare lectures. He therefore set his students to read Oxford professor William Blackstone's 4-volume work, Commentaries on the Laws of England, which had been published in the second half of the 1760s. This is a lot less strange than it sounds. Blackstone was the go-to source also for American legal professionals, for the simple reason that there were no textbooks in American law in 1790. Wyeth had used Blackstone too. But if the choice was uncontroversial, it was also problematic. The laws of England were not necessarily the laws of Virginia, nor of the United States. Much worse was the fact that Blackstone's commentaries was informed by ideas that ran counter to American political principles. So Blackstone was known for his defense of parliamentary sovereignty, which is the constitutional hot potato that caused the American Revolution. Now, reading Blackstone might therefore make American law students unwittingly absorb British political ideas, and because these students would then go on to become politicians, judges, and lawyers, this could possibly derail American democracy. Tucker's solution to this dilemma was guided reading, what he called making Blackstone safe for his Virginia students. In practice, this meant that he provided extensive comments on the Blackstone text, but also that he wrote many standalone essays on matters where Virginia diverged from Britain, such as the law of slavery. For my purposes today, the first 4 of these essays are the most important: of sovereignty and legislature, of the several forms of government, of the Constitution of Virginia, and of the Constitution of the United States. Tucker resigned from his professorship in 1804. By that time, he was already mad at the college for refusing him to work from home. This forced him to call something called a box chair, and I really don't know what that is, full of reference books from his house on Nicholson Street up Duke of Gloucester Street to a college classroom 3 times a week for his lectures, and then back again, so a distance of about half a mile either way. When on top of this, the administration demanded that he start taking attendance and inspect student halls, Tucker quit. And his letter of resignation accused the college of turning him into a country village school teacher, tasked with duties the performance of which must degrade the professor in the eyes of his pupils and of the public, and the man in his own eyes, duties the bare enjoining of which demonstrates a total want of confidence in the professors, not to say a perfect contempt for them. So, we fortunately, I think that modern universities have moved on from this kind of micromanagement. So I think quitting was made easier by the fact that Tucker had been appointed to the Virginia Supreme Court of Appeals, that's the highest court of the Commonwealth, in the same year that he quit. It probably also helped that he had the year before published the fruits of his 13-year labor as a law professor. 1803 saw the publication of Tucker's annotated Blackstone text, together with 28 of his standalone essays, in a 5-volume work known today as Tucker's Blackstone. This was well received, something of a financial success too for Tucker, and it was widely used in Virginia, but also outside of the state for decades, until replaced by the works of James Kent and Joseph Story in the 1820s. The essays that became appendices in Tucker's Blackstone were first written in notebooks preserved in the College of William and Mary Swem Library. And we know that Tucker was ready to go to press already in the mid-1790s, and there's much internal evidence in these notebooks to suggest that they are written in the mid-1790s. If we next compare the notebooks to Blackstone, a few changes in the published essays. So this means that the date of composition of the essays is not the early 1800s, but rather the early to mid 1790s. And this makes him contemporary with some other American jurists like Nathaniel Chipman, James Kent, Sophia Swift, and James Wilson. So in the rest of this talk, I will look at three contexts in which the terms constitution and written constitution appear in Tucker's discussion of American state formation. The first context is a short and straightforward declaration of the principles that inform American political organization. And this is found in Tucker's opening essay on sovereignty and legislature. The second context is his insertion of the term constitution in natural law theory of the social contract, which at this time was the dominant language in which jurists discussed the creation of society and government, and also his accompanying thoughts on the significance of the written constitution. This discussion is found in Tucker's second essay of the several forms of government. The third context is Tucker's analysis of the constitution of Virginia and of the United States. So Tucker's first essay was a very short but also very important text of sovereignty and legislature. And Tucker took aim at the central tenet of Blackstone's political theory that sovereignty resided in Parliament. The essay used as an epigraph Blackstone's claim that sovereignty and legislature are indeed convertible terms. One cannot subsist without the other. While this might be true of Britain, Tucker argued that the American Revolution had formed a new epoch in the history of civil institutions, causing a transatlantic rift in political principles. In contrast to Britain, American government was created by an original written compact that drew a distinction between the indefinite and unlimited power or sovereignty of the people on the one hand, and the definite powers of government on the other hand. He called this written compact a written constitution, and this is the first time that the term appears in his writing. This short essay summarized an important principle but didn't really explain the function of constitutions in American state formation, and Tucker offered this explanation in a longer essay on forms of government. The language of compact of sovereignty and legislature points to Tucker's grounding in natural law and the theory of the social contract, a concept that early modern natural law writers themselves never actually called contract, but rather covenant, agreement, or compact. The basic elements of this theory are well known. It explains how society and government originate in an agreement between unrelated individuals in a state of nature to decide to form an association and to live together under a government of their own making. To modern ears, the social contract sounds much like a written constitution, but we should note that none of the great contract theorists, Thomas Hobbes, Samuel von Pufendorf, John Locke, and Jean-Jacques Rousseau, ever referred to the social contract as a constitution. And none of them ever said anything about the contract being written. Today, Hobbes is considered to be the most important contract theorist by political theorists. Students of the American Revolution see Locke as the principal influence. Tucker relied on neither of them, but instead used the 17th century German jurist Samuel von Pufendorf. And if this sounds like an exotic choice today, it really wasn't in the 1790s. Pufendorf's version of the contract theory had been picked up by natural law authorities like Barbara Berla-McKee and, as we will soon see, Vattel, who could all be found on the reading lists of 18th century law students. So the full details of Pufendorf's theory of state formation need not concern us, but it's important to know that he conceptualized the contract not as a single action, but as three discrete steps. 2 covenants and 1 decree. In the first step, free men agree with one another individually to enter into union and to manage their safety and security together. In the second step, these free men decree the form of government according to which their association or society will be ruled. And this can be a monarchy, it can be an aristocracy, or it can be a democracy, or a mix. In the third and final step, the association of free men confer the powers of government on their designated ruler or rulers, and this is an act that is binding on both parties. The ruler agrees to provide for the common security and safety in return for obedience. So, back to Tucker. His essay on the several forms of government opens with a set of preliminary remarks which explains the origins of society and government in social contract terms. And as you can see here, he is using the term state in the same way that Wilson did earlier, meaning people or nation, and it's a translation of the Latin word civitas, originally meaning city. So what he says here is that a nation or a state is a body politic or a society of men united together to promote their mutual safety and advantage by means of their union. From the very design that induces them to form a society that has its common interests and ought to act in concert, it is necessary that there should be established a public authority to order and direct what ought to be done by each in relation to the end of the association. This political authority is by some writers denominated the sovereignty, but for reasons which will be hereafter explained, I prefer calling it the government or administrative authority of the state, to which each citizen subjects himself by the very act of association for the purpose of establishing civil society. These words are not for the most part Tucker's, nor are they Pufendorf's. The first two paragraphs are an attributed pilfering from Swiss jurist Emil Vattel's Law of Nature. But the third paragraph is Tucker's own. And here he parts company with Vattel, who in the original says, this political authority is the sovereignty, and he or they who are invested with it are the sovereign. Tucker's version instead conforms to his declaration of sovereignty and legislature, saying that sovereignty resides not in the government but in the people. It is inherent in them and unalienable from them. Tucker was far from alone in going against Vattel and Pufendorf. By the 1790s, virtually every American political writer accepted that government was not only created by the people, but that the people retained their sovereignty and therefore their right to reform their government at will. And you can find this point made also by people like Chipman and Kent and Wilson. If Tucker disagreed with established natural law theory on the question of popular sovereignty, we should note that he nevertheless continued to conceptualize the social contract as this three-step process. In his borrowing from Vattel, the first paragraph corresponds to Pufendorf's first agreement, by which individuals in a state of nature form a union or association. The second paragraph corresponds to the people's decree, their form of government, which is the second step of Pufendorf's theory. The third paragraph, where Tucker diverts from Vattel, corresponds to the third step of Pufendorf's theory, the conferring of the powers of government on a designated ruler or rulers. Like Pufendorf and Vattel, Tucker believed that this third step consisted in appointing a government, but he didn't think it meant that the people had to part with their sovereignty. As you could see, Tucker's preliminary remarks spoke of creating a public authority, but did not mention a constitution. This term instead shows up in the first section of the essay, where Tucker offers a longer account of state formation, and where he uses not only Pufendorf's theory, but also his terminology. Here, Tucker writes of the agreement of contract, by which each individual may be supposed to have agreed with all the rest that they should unite into one society or body, of the decree or designation made by the whole people of the form or plan of power, and of the appointment of persons to administer the government. It's at this point in the argument that Tucker inserts the term constitution into contract theory by saying that the decree is what we now understand by the constitution of the state. So, in other words, Tucker here defines constitution very precisely as the second step in Pufendorf's state formation theory. This may seem like an obvious move today, but it wasn't necessarily at the time. If we turn to James Wilson's law lectures from 1790-1791, he uses exactly the same Pufendorfian origin story as Tucker does, but he has no use for the term constitution in that theory. Like Hobbes, Locke, and everyone else, Pufendorf had nothing to say about constitutions being written, but Tucker, in contrast, emphasized that the plan of power, as he called it, was put in writing. Since the general use of letters, he remarked, the most natural method of constituting civil power must be some deed or instrument of convention. And this remark on the history of writing was meant to address a common objection made at the time, not least by Blackstone, namely that no matter how hard you searched in the archives, no one had ever found an original social contract. So this might be a true argument for Europe, where the origin of society and government was shrouded in the mist of time, but things look very different in the younger polities of North America. At the Revolution, Americans set up new governments by adopting constitutions formally expressed in visible form or writing, which had then been widely promulgated. This turn of phrase, a visible constitution, may sound odd, but Tucker knew what he was doing. In 1791, Thomas Paine used a passage of Rights of Man to mock Edmund Burke for the latter's praise of the British Constitution. How could Burke celebrate something that did not exist? Paine asked. He ought to know that a constitution is not a thing in name only, but in fact. It has not an ideal, but a real existence. And whenever the constitution cannot be produced in visible form, there is none. The constitution is the body of elements to which you can refer and quote article by article. Paine's contemporaries certainly took note of this new definition of constitution. On both sides of the Atlantic, there were people like John Quincy Adams who defended Burke's older understanding of the word. But Tucker sided with Paine. He cited Rights of Man at length. Both men believed that a single document constitution would make the constitution transparent and therefore make it possible for the people to hold their government to account. In Tucker's words, a written constitution has the peculiar advantage of serving as a beacon to appraise the people when their rights and liberties are invaded or in danger. Tucker believed that the American Revolution had given rise to what he called a new political phenomenon, namely a written constitution framed and adopted by the people of every colony. When he turned to analyze the constitution of his home state of Virginia, he stuck to his definition of constitution as a Pufendorfian decree. The most obvious consequence of this is easily missed, but we should note that Tucker's essay of the Constitution of Virginia took the form of textual exegesis. There's actually no sign of an older understanding of the meaning of constitution as political system or political culture greater than the written form of government, as in the Bolingbroke quote. There is no indication that Tucker thought the Virginia Constitution was anything other than the document bearing his name. Tucker's understanding of the Virginia Constitution as a Pufendorfian decree had another important consequence. It forced him to explain how the people or state of Virginia could have acted as the constituent power of government when Virginia had used neither a constitutional convention nor popular ratification to draw up and approve its constitution. In fact, the first 15 pages of Tucker's essay is a long defense of the position that Virginia even had a constitution in the first place. And this was all Thomas Jefferson's fault, because in the notes on the state of Virginia, Jefferson had claimed that the Fifth Convention, which both drew up and approved the Virginia Constitution in May and June 1776, did not have the authority to do either of these things. To Jefferson, the Virginia Constitution was nothing more than an act of the Legislative Assembly. It had no higher authority than a regular statute or regular law. If one assembly could write and approve a constitution, so could the next. Readers of Blackstone would recognize that Virginia was therefore no better than Britain. In Virginia, too, sovereignty and legislature were convertible terms. Tucker got out of this dilemma by a forceful endorsement of the principle of popular sovereignty on the one hand, and by a radical dismissal of the claim that the people could only act as the constituent power through the means of constitutional conventions and popular ratification, on the other hand. According to Tucker, the Fifth Convention meant one royal government had been dissolved. By definition, it simply could not be a continuation of the old Virginia Assembly, as Jefferson claimed. Tucker made a virtue of the fact that the convention had not the shadow of legal form about it. He declared that the convention was either nothing at all or something superior to an ordinary legislature. And to Tucker, it was without question the latter. Rather than a branch of government, the Fifth Convention was the embodiment of the people of Virginia called together in the extraordinary circumstances of revolution. He called the convention variously the people themselves, the voice of the people, and the great body of the people assembled in the persons of their deputies. He compared the Fifth Convention to both the English Parliament in 1688 and to the French National Assembly in 1789, and quoted the radical English author James Mackintosh to the effect that great revolutions are too immense for technical formality. To Tucker, the Fifth Convention derived its existence and authority from a higher source, a power which can supersede all law, dispense with all forms, and whenever it pleases, annul one constitution and set up another, namely the people in their sovereign, unlimited and unlimitable capacity and authority. If the Virginia Constitution exemplified how a people decreed the form of government, the US Constitution was a different beast because it represented not one decree, not the decree of one state, but the decree of 13 states. Because the new federal government operated directly on individuals, the decree required individual consent, but Tucker always said that such consent was not given by individuals composing one entire nation, but by individuals composing the distinct and independent states to which they respectively belong. The Constitution did not spell the end of the states as independent polities. It was not a flame by which they have been consumed, nor a vortex in which they are swallowed up. We should remember that Tucker is here speaking about states as distinct and sovereign peoples, not as governments. Adoption of the Constitution did not, to his mind, change the fact that each state in the Union was still a perfect state, still sovereign, still independent, and still capable to resume the exercise of its functions in the most unlimited extent. When the American states approved the Constitution, they invested part of their sovereign power in a federal government of enumerated powers set up alongside their state governments. The two-tiered structure institutionalized a division of labor, whereby the federal government was put in charge of foreign and inter-union matters and the state governments of domestic matters. Crucially, however, it was only the powers of the former government that were strictly enumerated. And Tucker stressed that the administration of what other concerns remains with the states forming the Confederacy. Enumeration of powers was the chief means in the Constitution to restrain the federal government from invading the sovereign power of the states or of their governments. In 3 sections, the Constitution enumerates the powers granted to Congress, the powers forbidden to Congress, and the powers forbidden to the state governments. In tracing the line of separation between the jurisdictions of the federal and the state governments, the clarity of the enumeration of powers was, of course, essential. In this essay on the US Constitution, Tucker returns to the topic of writing, and he makes a point of saying that, among many other things, the Constitution is a written contract. He also found that it was a contract reasonably well written. In the Constitution, the structure of the government, its several powers and jurisdictions, and the concessions of the several states generally are pretty accurately defined and limited. this key principle that the powers of the new federal government were limited and that the states in all unenumerated cases were left to the enjoyment of their sovereign and independent jurisdictions was confirmed with the adoption of the 9th and 10th Amendments, which Tucker noted had been added to prevent misconstruction or abuse of the powers granted by the Constitution. Tucker's reflections on the advantages of a written constitution at the federal level, which contains yet another swipe at Britain and Blackstone, is a good place to end my talk. According to Tucker, undefined power soon becomes unlimited power. Without a text to resort to, ordinary people will not know their rights. Yet such knowledge is necessary for the preservation of free government. In nations where popular sovereignty has been usurped and where the people have no share in government, ignorance might be a blessing. But where the sovereignty is vested in the people, government becomes a subordinate power and is the mere creature of the people's will. It ought therefore to be so constructed that its operations may be the subject of constant observation and scrutiny. There should be no hidden machinery nor secret spring about it. Now, when the Kinder Institute hands out these 3 copies of the US Constitution on Constitution Day, and I can tell you I'm lucky only on no less than 4 of these, it acts in the spirit of Tucker and other founders in presenting the meaning of the Constitution as transparent, open to all who can read and reflect. And this has important implications. If the Constitution's meaning is transparent, the people themselves can judge if and when their government acts against it. But of course, constitutional understanding is only the first step. The people also have to have constitutional means to correct their governments. And Tucker thought they did. But contrary to modern constitutionalism, he did not think it fell to the judiciary to rein in a rogue government, but to the people themselves, acting through federal elections and constitutional amendments initiated by their state governments. But that, as they say, is a different story.
All right, so we have usual time for questions. And I'd like to open it up with a question from an undergraduate or MA student. You're going to force me to ask a question.
Tucker was a professor. What mainly did you do, and what kind of essays would you write while teaching law? And what kind of law did you work with in when he had his lawyer career?
All right, so instructions in law at this time was mainly self-study. And it would cover all kinds of law from the law of nations to the common law of Virginia, but because the common law of Virginia had been shaped so much by the common law of England, you also have to know a lot about the common law of England, you know, the law of Virginia. His teaching tends to be referred to as lectures, but according to reports, it was more like a seminar. Students would read things in advance, and he would test them, asking them questions. And he would also prepare. The essays were used as lectures to make sure that his students understood the ways in which Virginia and the U.S. Was different from England. We do know quite a bit about how he taught. There are preserved lists of recommended readings and things that he gave to his students. some of his students wrote down their memories of his teaching. So, yeah, no, I don't know if that's enough of an answer to your question, right? Thanks.
All right, so as people think things over, I'll throw out a question, which is that what I was hearing is a clear sense that Tucker felt that a written constitution would be clearer, right? That would give people a clearer sense of their rights. And I was wondering where the purpose of the constitution fit into that. Did he feel like a written constitution, as he conceived it, changed at all the purpose of the constitution? Is it meant to be something that is clearer, but perhaps is still making the people better and elevating them? Or is it reflecting them more clearly? What is the role of purpose?
I think that this is framed against the backdrop of perceived abuses of power by the British government, and then perceived abuses of power by the federal government in this early 1790s. So I think he's not unusual among Americans in this period of accepting the necessity of government, but also really fearing the possibility of government abuse. And that's the main purpose of constitutions, to make sure that this contract that sets up your government is something that you can go and refer to. You don't have to trust your leaders when they tell you, you gave me the authority to rule, but you should have this standard by which you could hold into account and make sure that they're not grasping any more power than what you gave them. Now, you can have all kinds of views on that. It's clearly anyone who's studied literature or text will know that it's a fairly naive view of the transparent meaning of text, and believes that meaning will not only be the same for you and me, but also stay the same over time. But they seem to be really optimistic, and they seem to think that this is just a great new thing. It's going to make a difference. If it did, yeah.
Thank you. I have sort of a question that maybe follows along that reasoning a little bit, and that sort of gets into some of the modern sort of legal theory at play, which is sort of this question that simmers throughout about the nature of consent and legitimacy. It's sort of this like popular line, especially amongst some originalists now, about whether or not consent is actually important to the Constitution, or that that's what it's there to establish, and whether or not that's a practical way of understanding how the Constitution derives its power. And so I'm just wondering, are any of these debates playing out for Tucker at this time? How is he thinking about the process by which, if citizens give consent to this, that actually works, or is he just sort of unconcerned with the practicality of that?
Well, all social contract theory is based on consent, and it's really a key concept. You cannot force anyone to live under a government. You can only establish legitimate government by people consenting to live under that government. So in that sense, it's a very central term. But what I said about the establishment of the Virginia Constitution shows that he can be fairly relaxed about the institutional forms by which you register this consent. And in that sense, the language he uses there is the language of modern revolutionaries or modern populists, for that matter. He just decides what the people is. It's a little bit more sophisticated than what I said, because he argues that the members of this Fifth Convention were appointed by the counties in Virginia, and in Virginia at the time there had been a long discussion about the next step in the struggle against Britain. and everyone supported the idea of independence. But if you were going to become an independent state, then you would also need a government, right? They had provisional governments at the time. They didn't have a real legitimate government. So he argues that it's implied in the fact that the Fifth Convention had this mandate to declare Virginia independent, that it also had a mandate to set up a government. Because after all, Virginia is an association of people, and they club together to live under their own government. So how can they create a situation where they're not going to have a government? Because that is down the line going to lead to the disintegration of Virginia as a state, as a people, as a community. But yeah, so just a short answer to that is, I guess, consent is really, really central. And just sorry.
Thank you. You brought up judicial review towards the end of your lecture. I was wondering, when he was kind of outlining his thought on on constitutional democracy, did he have any predictions in any of his writings or stuff of like what it would become and how it would progress in a more modern sense? Like any predictions of things that ended up arising because of it?
Yes, in some ways. I mean, they all thought that a republic was a very fragile thing. They all assumed, because they had this cyclical theory of political development, that the republic would become corrupted, and in its place you would get tyrants. And the big fear was executive overreach, creating something that was worsening, because it could at least, in some cases, be someone who abided by the law. So the big fear was this executive person who acted with complete disregard to the law, I guess. I don't think a lot of people at the time even the lawyers and the jurists thought that the courts would become as important as they did in the US system. Trump is really focused on elections a lot in his stance. He sees the protection of the republic. As long as most people who are citizens have the right to vote, they will be able to keep this to defend the system. That doesn't mean that everyone in early America had a duty to not do anything unconstitutional. So if a court was asked to do something unconstitutional, they had a duty to refuse. But it doesn't mean that they have this status that it will give to the court of the US system gives to the court today.
My question was revolving around the expansion of his ideas of the Constitution, how he views it, if it should be changed or static. Was he a living constitutionalist? Having any thoughts about like Thomas Jefferson's ideas of generational sovereignty, rewriting it every 20 years, or was there, just more ideas and thoughts if he had any writings or opinions on how the Constitution should be changed, if at all?
Like a lot of people at the time, he thought if you change it when you had to, there's nothing sacred about it. And again, it comes back to his belief that as long as real power is in the people, if they need to change the Constitution, they will do so. Although he doesn't agree with Jefferson on Virginia not having a Constitution, he agrees to a large extent with Jefferson on other points, and he thinks that the Virginia Constitution ought to be amended or rewritten. Contrary sort of with most of the classic historians who've written about this period, they all tend to say that the constitutional conventions and all of that is really a really important development in the American Revolution. But he's not interested in that. He seems to think that the people are basically sound, and as long as they can vote on the right representatives and get rid of the wrong representatives, everything is going to be fine. So I don't even know if he thinks that the Virginia Assembly has the right to make changes to the Constitution. It's not something that he writes about as far as I know.
I was going to ask you one thing, and now I think it might be something else based on what you just said, but we'll see. So answer whichever part of this dyad that you so choose. So the first part is, first of all, I loved hearing this for being here, really exciting stuff. The first kind of question that I had was, where does common law fit into this story? When I think about Tucker and writing commentaries on Blackstone commentaries, I'm thinking that he's talking about the common law, he's affirming the common law, but he's also saying that we're doing something different in the United States, and to some degree is his emphasis on the written constitutionalism part of that kind of reaction against the common law? Where do you situate it broadly? I guess the thing that just sparked in my head, the kind of other kind of question I could ask, and again, I don't want to take up too much time, is, it's interesting to hear you say that you want to kind of distinguish yourself from that kind of golden boy tradition, which I totally understand. But there's also a very, I think, real read of this story that is part of a kind of more celebratory narrative of the U.S. is the birthplace of constitutionalism. And so I wonder if I could hear you more talk about what distance are you trying to create from that more kind of celebratory and at times.
All right. Lots of interesting questions. No one who is a lawyer at this time is against the common law, right? So that is what he's teaching his students. What is noticeable in this period is that there's a movement towards the codification of the common law to standardize and to collect the law in one place, which I think is related to his belief in the use of the value of a written constitution. The other question, celebratory account or not, I guess I'm not sure I would call it a celebratory account necessarily, but I think something quite important does happen at the time of the American Revolution. It may not be that it's actually happening at the time of the American Revolution. It might be that it's happening at the time of the French Revolution, when Tucker is reimagining what happens in that revolutionary moment. And he, not really courses through, but it seems in some ways like he is trying to make the American Revolution something that is universal. So he's taking it out of a history of Britain to become a universal story of human emancipation, and we need to remember that he's not that interested in all humans, only himself. But his language is much more universal, much more natural law. And I think it may not have led to good things necessarily, but it is something that seems to me new, that is happening, and quite important from the perspective of intellectual history, at least. I might be trying to think next superstar historian there. Gordon was the second. Never mind that.
Worse outcomes.
Yes.
Thanks, Max, so much. I really enjoyed the talk. I wondered if you could go back to the slide where you have the PDF of Tucker's in his table of contents.
Oh.
Next to the, yes. So here's what I'm curious to know. as you mentioned, Jefferson, well, founders generally were concerned as law students or Blackstones that are absorbing Tory ideals. And Jefferson was super excited when Pepper's commentaries came out. So if you were a law student at the time and you took Blackstone's commentaries and put them next to Pepper's Blackstone, what would look different in the volume? How does Pepper's commentary come in? And then when you were looking at the volumes, what was maybe something that was very surprising to you or that you didn't expect to see when you started getting into the weeds on Pepper's changes to the text?
Well, I think it's really the way he starts their arguments. That first essay, that he sees that as the main thing where he has to refute Blackstone and show him that he misunderstood how East American polities are organized. It's really about a question of sovereignty, and this is important because law, according to Blackstone, was sovereign command, right? So who the sovereign is a key question, and he's making this point again and again and again that in America the people is the sovereign. So that to me is one of the major things about how he designs this. In other ways, it's just, I guess what really strikes one is how strange it is that he's not writing his own book. He's reprinting this Tory Oxford professor. And so that's the text, and then he has any number of comments explaining why this is not necessarily the case in the US or in Virginia. But I think it makes it so interesting that so I thought of this as a post-colonial literature in a very direct sense, because Blackstone is state-of-the-art in Britain, and when the Americans have to think through how they're different from Britain, they take this state-of-the-art account of what Britain is, and then they go through it and reflect on many ways in which something new has happened. So, throughout his essays, Britain pops up all the time, and very rarely something positive. This system that is defective or corrupt in different ways, and even if things where they might have got things right, like mixed government, it turns out that the US are much better at that too. So,
all right. So
Anglophobia, I guess, is a striking thing about this project.
we've got time for a couple more questions. I'm going to take them in physical proximity to me.
I hope you'll forgive me for dragging you into the historiographic debate that you explicitly said you didn't want to be dragged into. But I find it odd or surprising that people who were, say, at the constitutional conventions would not be out trumpeting how radical this is to be writing it down and have a written constitution. So is that really true that people who were at the convention were not remarking on it? And if so, why would they have not viewed this as important, but a lawyer, professor, observer would have seen this? Why would that have not been recognized by the people who were supposedly the innovators?
Okay, thanks. Can I answer now?
Yeah.
Okay. So I did a little test. I went to the Founders Online database, which is this database that has like 180,000 documents from the founding period. So documents written by or to founding people from 1750s maybe to 1830s. And I typed in government, and it appears, I think, 31,000 times. I typed in constitution, which appears, 15 to 20,000 times. I then typed in written constitution, and it shows up 16 times. So I think Knapp might be onto something. He's the guy I cited. So the question then is this a post-Paynian thing? Is it his attack on Burke that elevates the idea of the written constitution, so post-French Revolution development really, rather than something that originates in America. So it was when I was reading this literature that I was struck by the fact it's not just that Tucker mentions the written constitution every now and then. He's quite clear on thinking that it's a key part of why America is better and different. So, in answer to your question, I need to read a little bit more about this, but he's quoting Paine, so he seems like the most likely candidate for having made this opinion. But yeah, I agree with you. I was also surprised when I read this literature first. It seemed like an obvious thing for them to celebrate.
So I guess I get the last question, Max. I loved the paper. I was thinking through the whole time about if the administration made all the professors of the Kinder Institute go check in on their students in the dorms. How many of us would quit? How many of us would like that? But I want to start a conversation between current Max and past Max, or young Max and future Max. They're all wise and handsome Maxes, both of them. But really different because your first stuff on the Constitution was really, 35,000 feet, bird's eye view, fiscal military state. This is an instrument of power in a volatile international environment. It's young Max. Present Max, diving in, one professor's take. You're not really interested, you're not talking about the big context, you're talking about political theory and ideas and how those get bounced around. And if there is a kind of Atlantic context, it's how these thinkers are kind of dunking on one another, nitpicking at one another, and they're doing it kind of indirectly in their notes. So I guess what would you want to say to young Max? And what would young Max say to you today about these different takes on the Constitution?
Okay, that's very easy. It's the same. It's the same old Max. It's going to be the same all the time. So my first work was very much focused on international history and the really troublesome international context that the US found itself in. And I always felt that didn't mean that there weren't other important things going on. So this is just me turning to those other things that are also happening. What's going on domestically? What's going on with this whole idea of the US being created as a democracy and as a place of liberal rights? And what's really useful and interesting to me about Tucker and this conception of what a state is and how it is formed is that it allows me to discuss exclusion, which is a big thing for them, and how their state is in terms of the people who belong to that state or to the people, they're very few. And what's nice about the lawyers is they don't have a problem with this. They explain that women and children and servants are subordinate, enslaved people are also subordinate. We have everything starts in the state of nature where women attach themselves to men, and beta males attach themselves to alpha males, and they form little communities that are families. And then in the next step, these families form associations that are peoples, but these peoples are not, it's not the inhabitants, it's those heads of families. Kuggenrod is great because he says explicitly, it's the heads of families that club together. and they bring together with them all their household dependents. So you are right that if I started out with a bird's eye view, I am now starting at the other end, and the more I read and the more I think about the early US, the more I think that it's a system built from households. So that is the key governmental institution, household government. And the lawyers allows us to see that in a way that Madison and Jefferson and others really don't. So that would be my answer. And that story is not so natural. It depends on your political viewpoint, I guess. It would be some.
All right. Well, the cool thing is that we get this particular conversation going all academic year. But a couple things before we thank Dr. Edwin. The first is that if you are in the mood to continue your intellectual festivities this evening, the Missouri Debate Union is having an event in this space at 6 p.m. and you're welcome to take part and participate in that. And then secondly, before I invite you to attend famed Pursuit of Happiness Hour, the Holidays Edition, I want to give a shout out to Kylie Schmerbeck. I don't know if she's like, there she is. I love it just started laughing. You don't know why I'm giving her a shout out yet. But Kylie has been our Kinder ambassador on point for putting the spread out after all of our colloquiums for the past few years. And this is her last day on duty, right? She's elevated it to an art science. And so that's why I want to make sure that we recognize that today. All right, so have a good break, everyone.